for those of you in practice, you know that complaints come in a variety of different sizes. You have complaints which are relatively trivial, so they could be things like, you didn't see me on time, to the very serious issues, because of what you have done, there's been some physical harm that's been inflicted. So there could be very different issues that arise out of the complaint that you received. They could be conduct, they could be negligence, and they could affect your reputation. As I said, Rizade will deal with the conduct, and I'll be dealing with negligence and reputation management. Today is not about giving you an in-depth overview of the law, but it is to kind of help you identify the red flag issues when you receive a complaint. You may not be able to read all of this, but it is in your seminar sheets. What I've done is just put up a sample complaint letter, and the reason for that is so that we can refer back to this when we're talking about how to deal with things practically. Essentially, in this letter, it's a letter from a daughter who's lost her father because of lung cancer. She says she's written to her medical doctor in his practice. She says, look, you didn't look after my father, you didn't ensure that his records were properly kept, he was seen too late, your service was deficient. As far as I'm concerned, it's because of your negligence that he wasn't treated, and then he passed away far too early. And she also goes on to say, I'm going to report you to the GMC, which is the regulator for doctors, and I'm going to be highlighting your failings on social media. Now, that letter raises lots and lots of issues. It raises issues about negligence, it raises issues about conduct, and it raises issues about what you do about your reputation. It takes 10 years to build your reputation and about 10 minutes to destroy it online. So the reason for that is to kind of say, when you receive a letter like that, it's not just a matter of saying, here, insurers, take a look at it. It's to understand what it is that is being said, particularly if very serious allegations are being made, like negligence. So look for the red flags. In this letter, she says, because his lung cancer wasn't discovered until much later, he wasn't given meaningful care. That is a negligence allegation. She's saying, because of what you did, it caused my father's early demise. So I'll move on from this, because we'll keep referring back to it. Dealing with complaints. As I said, many practitioners in the room will already know how to deal with a complaint, will have a complaints policy in place. There's lots of useful information out there. I'm not going to go through that. But what I will say is that if you are running a practice where you are dealing with private patients, there is scope for you to manage the complaint in a way that you may not be able to do when you're managing NHS patients. And that's because you do have terms of business. And you can amend your terms of business or have terms of business which can agree a process to manage a complaint. Now, a colleague of mine who's a claimant-focused solicitor who deals with personal injury claims said to me, look, 9 times out of 10, what patients want is not money. It's surprising that you might hear that, but actually what they want is some kind of mediated settlement, some kind of apology. So actually, if you are able to build into your complaints procedure and your terms a way of facilitating that, then it's very important to have that information. We've already talked about considering what kinds of allegations have already been raised in your complaints letter, so I won't talk about that again. As I said, follow the complaints procedure. Ensure that if you are able to deal with it in some kind of alternative way, there are lots of different adjudication services out there. So if you are able to have a matter mediated or dealt with outside of the litigious process, then it is very beneficial to both the patient and the healthcare provider. And that's because, as I said, people aren't always looking for the monetary compensation. They might just be looking for an apology. And I'll talk about protected apologies later as well. When you get your letter of complaint, most practitioners will pick up the phone to their insurer. It is a good idea to do that, either your insurer or your legal advisor, because you should never undermine your own disciplinary or legal case, because if serious allegations are being made, then it is imperative that you're protecting your position. So before you respond to a letter of complaint, make sure that you've spoken and taken appropriate legal advice at an early stage. Let's talk about the serious things. So, negligence. For negligence to be proven, there have to be in law certain elements. I'm not going to go through them in depth, but the 4 key things you need to have are that there has to be a relationship of trust. Now, the law has found that in most circumstances where you have a patient, healthcare professional relationship, there will be a relationship of trust. So that's a given. There is a duty of care that's imposed, and that can arise out of contract and general law. If you breach that duty and a harm is caused to the patient, that's when you've got the elements to be able to show there is a claim in negligence. So you're looking for all of those 4 things before a patient is going to have a successful claim. The duty of care is one which is that of a reasonable person. So in the healthcare industry, in the medical industry, that is the duty of care that says that it's whether there is a responsible body of opinion that would have done the same thing that you have done. So if there are enough other people out there who have done what you have done, then there may not be a breach of that duty of care. The important thing on this slide is not that, because many of you will know that already. It's really this, is that if you do have terms of business with your patients, if you're working in private healthcare, then make sure that your contract doesn't impose on you a higher standard than the law does. So, for example, it shouldn't impose an absolute performance obligation, so make sure you read your own terms of business properly and ensure that the scope is restricted appropriately as well, because you can sometimes inadvertently impose a higher standard of care on yourself than you might need to. I won't go through what's called the Bono Test, but that is the standard test that is applied to healthcare professionals. As I said, it is the practice accepted as proper by responsible members of your profession. What is important for healthcare professionals now is a landmark decision in the Supreme Court, which is a decision by 7 Supreme Court judges, so it's not something to be dismissed. And that was earlier this year in Montgomery versus Lancashire Health Board. Essentially what that case says is this, that it's no longer appropriate for, and this was involving a doctor, so we're talking about doctors, it's no longer appropriate for doctors to simply say, these are the significant risks, do you consent to them or not? What the doctor now has to say is, these are all of the risks, significant or not, do you consent to them or not? And that's a very big difference, because initially you could have said, if there's a 1% chance of something going wrong, you may not have had to disclose it. But now that may well be a risk that you want to disclose and ensure that you have recorded. So it's much more patient-focused. It's no longer about the doctor saying, these are the things that we should be worried about. It's about making sure the patient knows everything. Now, as far as I'm concerned, that's fairly ludicrous, because as any kind of healthcare professional will tell you, it's impossible to be able to cover everything, but it is a duty of care now that is being applied. And actually, this is what the GMC says. GMC says it really is about the patient making their own decisions. So even if you have reached your...
Is that just applicable to GMC?
Well, I mean, I'll take questions at the end, but I'll answer it briefly now. It deals with doctors, but we can talk about how it can be applied to healthcare professionals generally. So even if we're talking about having a breach of your duty of care, even if you've breached it, doesn't necessarily mean the law will say you've been negligent, because you still have to show that had it not been for your act or omission, that harm, would or would not have been caused. So it has to be the only reason why the harm was caused. So that's called the but-for test. So it may not be the case that it was because of your act or omission that the harm was caused. So in our example, the gentleman who passed away from lung cancer, it may not have been simply the case that he was diagnosed late. There might have been other factors as to why he wasn't able to get care towards the end of his life. The other things, I've put this slide in, sorry, before I move on, because even though we talk about, causation in very black and white terms, had it not been but for the act or omission, do remember that sometimes the courts have imposed a duty of care and have said there is causation because of policy reasons. So if someone has suffered very significant harm, even because of a very minor breach, the court has said because of the justice issue here, because of the fairness issue here, we're going to say negligence has been occasioned. So, but that will, apply to really clinical negligence cases. Okay, so moving on, causation. Even if, on causation, as I said, it has to be the reason why, that act or omission has to be the reason why someone's harm has been occasioned. And so as a practitioner, if you receive a complaint in which these allegations are being made, please consider what other causes there might be. It may well be that there's been another intervening act. It may well be that actually the harm is too remote. This is something that you could never have foreseen in any circumstances. So again, the law may not impose a duty of care on you. And also consider whether there's been other negligence, contributory negligence, we say in law, by the patient themselves. So these are all things to consider when you receive your letter of complaint. Because as a practitioner, don't just say, look, insurers, look at this, or legal advisor, look at this. Look at what other things are there so you know what kind of case you're looking at facing. Finally, to finish off my section, one of the things that is omitted by practitioners is managing reputation. Now, we live in a world where social media is very powerful, and on top of that, most of the time people will have some kind of website. There are lots of chat rooms out there to allow people to discuss their feelings about whatever service they're receiving. So, general statements of law to begin with. If someone says something potentially damaging about yourself or your business online or elsewhere, that could be a claim of negligence. If it means that it's lowering the kind of how people see you or your business in other people's eyes, and it's affecting your reputation. But how do you deal with that in social media? Now, one thing practically you can do is look at, if you have a website, look at your terms of use. You should be able to take down comments that you don't agree with. On your social media, again, look at whether or not they're defamatory or not and be able to respond to them. Similarly, if people are making comments in chat room forums. Now, what I put there is a role of a protected apology. I mentioned that earlier. So when you do respond, it is advisable where people are making allegations about your service levels, for example, to respond. But to respond in a way which doesn't affect the service that you're providing. You're making sure you're protecting yourself. So it's always useful to make sure that that's properly drafted. Some you may well be able to deal with yourself. So if someone says, look, I wasn't seen when I was meant to, but I was seen 15 minutes later, that could be something you can deal with yourself. But if people are making serious allegations online, it's worth speaking to a legal advisor about drafting a protected apology to be able to respond to that rather than leaving it out there for everyone to see. So, in summary, if you do receive a complaint, obviously handle it in accordance with the complaint procedure. Identify what it relates to. If it's raising serious allegations, speak to someone appropriate, your insurer, your legal advisor. Take action to address that complaint. So practically look at what other things have gone on with that particular case. And then, if you're talking about reputational damage online, again, look to see how you can practically deal with those things. And if people are raising serious allegations online, look to see whether you can get a protected apology drafted in those circumstances. As I said, if anyone's got any questions, we will take them at the end. What I'm going to do now is ask my colleague Bezade to deal with employment law and disciplinary matters. So I'm going to hand over to him. Thank you very much.